Okay, we'll go ahead and get started. Today's webinar is surrounding financial tips for your family law case. My name is Melissa Rosenberg and I'm a mental health provider, and I'm here to help facilitate the webinar and introduce you to Michelle from Dellino Law Group in just a moment. But I am here to kind of help get questions answered and field them to Michelle. What you can do if you'd like to ask a question throughout the webinar is put it in the chat. You can also put it in the Q&A. There's both options here. If you put it in the chat, it'll only come just directly to me. If you put it in the Q&A, others will see it. You can choose to mark yourself as anonymous. So just so you know that your name would pop up if you put it in the Q&A and you don't mark yourself anonymous. If anyone does have questions, we'll try to field as many of those as we can and hopefully answer as many of your questions as we can today about financial tips for family law cases. Somewhat unrelated, but also related, I'm a therapist and I work directly with clients who are dealing with difficult family law cases. I work with both couples and individuals who are navigating complicated emotional times as they work their way through their family law case. So just letting you know a little bit about who I am. I work in collaboration with Michelle's team and do work with a lot of clients from her firm and well as other firms to try to support a wraparound support for all of clients in this process. So I'm going to go ahead and turn it over to Michelle. Michelle Dellino is the owner and operator and managing attorney at Dellino Law Group, and she's going to fill us with lots of information today about financial tips.
Hi, thanks for being here. I'm Michelle Dellino. Like Melissa said, I am the owner and managing attorney of Dellino Law Group. We are a full service family firm that practices really all over Washington, but primarily in the greater Puget Sound area, King, Pierce, and Snohomish counties, Kitsap County, Thurston County as well, and sometimes even further counties. So anyway, what we're here today to talk about are financial tips and what to know for a divorce in your particular situation. And that can mean a lot of different things. I mean, financials, I'm just going to start by saying that financials are the reason for a lot of divorces, not all divorces, but sometimes things related to the financial realm can be a reason. Financials are also one of the most hotly contested issues in a divorce, and they are an issue that comes up in every divorce. You have some divorces where parenting issues are really big, and those don't happen in every divorce, but financials are part of every single divorce. Sometimes they're the catalyst for divorce, and there's something that you have to work through. So today what we're going to do is talk first about the different financial issues in divorce. I'm going to give you a few tips, a few things you're going to need to know that you're going to need to do as you start to think about this process and this journey for yourself. And then if we have time at the end, I think Melissa will, like she said, she'll take some questions and give me any questions that you have. I will do my best to give you some basic information. Keep in mind, anything I tell you today is not legal advice. We don't have an attorney-client relationship unless you actually retain our firm as your counsel. But I do like to do these because I hear a lot of the same questions over and over and over again. And a lot of people too also are very paralyzed by the divorce process, and finances are a really scary thing. So I think, I really believe the more information you have, the better. First thing you need to know too is that in every case, what you're doing is you are taking essentially resources that sustained one household, and you're going to have those same resources until things change, sustain two households. So that's a big deal. That's a big, scary thing. So we'll just keep that out there. That's why I say every case has to deal with finances. There really are four main issues in every family law case. I'll tell you what they are, then I'll tell you the ones we're going to talk about today. The first one is community property, and that is the division of debts and assets and how that relates to community property. That is an issue in every single case. That's like the big umbrella financial issue. We'll talk about a lot of things in that. With that today. The second one is spousal support. This is not an issue in every case, but whether or not spousal support will be an issue in your case is something that you're going to have to consider. It's not an issue in every case, but it is an issue in some cases. So that's another financial consideration we'll talk about. The third one is parenting and parenting plans. We won't really get into that today, except for as it relates to the fourth issue, which is child support. And that parenting and child support, those two twin issues obviously don't apply where there's no dependent children of a marriage. They can apply if you have maybe college age children, but the reality is if you don't have children under 18 that are not children that you maybe had before the marriage but are children of the marriage, those issues aren't going to apply. So we'll talk about the division of debts and assets and community property. We'll talk about spousal support, also known as spousal maintenance in Washington. In other states, known as alimony. It's all the same thing if you hear those terms. And we'll talk a little bit about child support as well. So those are the big ticket issues. What I'm going to do right off the bat is give you a tip, and that is gather your documents. Even if you are not sure if you're going down this road, even if you are just kind of hedging back and forth, gathering documents is a really important thing. You're going to have to do it no matter what if you do go down this road. If you don't, at least you'll have it and know that you did. But gather documents ahead of time, because sometimes once you take a step, then you can be in a situation where gathering documents can seem paralyzing, can seem stressful, and you might not want to do it. So just do it right off the bat. So first tip is these are the documents you need to gather. And I'll tell you where this little list comes from, but what I'll tell you is this. The things that would be really, really helpful would be pay stubs for the past 6 months. If you don't have, and I'll put it this way to you, pay stubs for the last 6 months, if you don't have like pay stubs as a source of income. If you're self-employed, get together your profit and loss statements if you have your own business. If you are receiving unemployment, get together unemployment statements. And also, I'll get to the bank account part in a minute, but you'll want to show where those payments are going. If you receive some kind of payments from a trust or if you're a beneficiary of some other kind of financial dividends, you're going to want to show that, but you need 6 months. I say preferably a year, because looking at a whole year of your income can be important, especially because some people might have a bonus that hits at different times or doesn't. So with the minimum that you need is 6 months of pay stubs or other documentation to show your source of income. That's the first thing. Second thing that you need is 2 years of tax returns. Think of it like you're applying for a mortgage or a loan, right? You've got to have these documents, stick them in a folder on your desktop or like on Google Drive or Dropbox or whatever you're going to do. Get them all organized too. The more organized that you are, the better if you have to share them later. But 6 months of pay stubs and then 2 years of tax returns. And that should include not just like the front page that gives you the summary of how it all broke down and how much you owed. That should include all schedules. For some people that do, a 1040 easy or something, or that's a very easy tax return to do. For other people that have a more complicated tax return, it can be a lot, but you just get it all together, your entire tax return. And it should include, like I said, all schedules and all W-2s. You need the underlying W-2s for your tax return. You're going to need those in this process. The next thing is if you are a business owner or you are self-employed in any way, you're going to need to have corporate tax returns, business tax returns. You're going to have to show those, even if you're claiming that it's not part of your spouse's business. You're going to need to have those. So if you own 5% or more is the basic rule. 5% or more in a corporation that generates its own tax return, you have to have the complete tax return, even if you're not the owner, for the prior 2 years. And here's the big one that's the most time-consuming one. Those aren't even the time-consuming ones. You are going to need 6 months. Again, I like to say a year while you're preparing, but the last 6 months to current of any financial institution that you have an interest in, statements for that. Financial institutions mean banks, credit unions, mutual fund companies, brokerages. It can mean mortgage statements. It does not mean utilities. Attorneys don't need to see your utility bills. You might want those. We'll talk about that later. But anything you owe money to that you make a regular payment on, anything that holds money that you have, 401k statements, taxable accounts like general brokerage accounts, Ameritrade, Charles Schwab, Chase Bank accounts, any kind of bank accounts you have, any mortgages you pay, any car loans. Also good idea to do your credit cards, 6 months of credit cards. Best thing you can do is create a folder for each account and then label the statements January 2020, 2021 actually, I guess, whatever, and stick it in there. So that is the most time consuming one, but you will need that, and I'll tell you why eventually. The other thing too is if you receive any non-taxable income or benefits from anything, you need to have documentation of that as well. So why you're getting these documents together is because two things. Number one, you guys in a divorce, everybody's going to have an option to see what the other party has. You can't come to a settlement if you don't know what you're settling on. So you're going to need to have both parties out there with their financials being transparently exchanged at some point, whether it's going to be willingly or whether it's going to be because there's a motion in the court or whether it's going to be through financial discovery. But this list of documents I just gave you is what the court is going to require if there is ever a motion before it where someone is seeking financial relief. So if someone says, hey, I want temporary spousal support, or I want child support, or I want attorney fees, if I need any kind of financial relief, you have to provide those documents at a minimum, and the other party will also have to provide them. Therefore, they are very common, and that's in King County. Therefore, they are very commonly the documents that are exchanged between parties to get a baseline understanding of what the financial assets are. So anyway, get those financials together. You will be glad you did. Put them all in a little folder, and then that way if you need to send them to your attorney, it'll be much more time and cost effective for you. So highly, highly, highly recommend that you do that. That's the first tip I'm going to give you. Excuse me. The second thing I'm going to tell you is what are the fundamentals of community property? Because if we're going to start talking about what there actually is to divide, we're going to need to talk about how do we know what that is? How do we know how to divide it? What do we do, right? So the first thing that you do in any divorce is you figure out what's the community property. What is that? And you hear that term a lot. What does that even mean? Well, community property means everything that belongs to the community, which a marital community is what we're talking about. We're talking about a community association. We're not talking about you and your friends. We're not talking about you and a boyfriend or girlfriend, although that can create community-like property, but that's a story for another day. In a divorce, we're talking about property that belongs to a marital community. And when does that start? This is a tricky question in Washington. A marital community can start when the parties are married, and it ends when the parties separate. So if somebody moves out, you guys still might be married, but that's your day of separation. That's when the community ended, okay? And when it started is a bit more of and that can be a tricky question too. People sometimes will say, oh, I moved out, but we were in counseling. Well, maybe the community hasn't ended yet. There's the date the community ended can be something that's up for discussion. But basically, from when a marriage starts to when a community ends, everything in there is community property. When it starts is another question. It's not always as easy in Washington as saying it just started with when we got married. And I'll tell you why. And the reason why is, hang on just a second. Okay. The reason why it's not always so easy is because Washington recognizes what are known as committed intimate relationships. So committed intimate relationships mean that if you cohabitate with someone in Washington, if you've ever been on a webinar before, you probably heard me talk about this. But when you cohabitate with someone in Washington in a stable, committed, marriage-like relationship, there can be a claim for all assets and debts during that time. So what happens in that situation is if it tacks on to a marriage, then it's very likely it's very likely that it would be included in the community period. So let's say you live together for 5 years. Let's say that you lived together for 5 years and then you got married. So if that happened, then instead of it being, let's say it was a 10-year marriage, instead of it being 10 years of community property, it might be 15. And that's a whole other issue about what does and doesn't count as committed intimate relationship time. But just assume if you got married and you lived together before you were married, just assume it's going to start when you started cohabitating. So what is community property? It's everything in that period. What I typically would do if we were sitting down the way we used to do things in a consultation, I like to draw a little picture and go, okay, here's the community, here's the year it started, here's the year it ended, here's the big circle, right? And then everything goes in there. So assets, debts, houses, retirement, stock options, everything that you have. And then you back things out that might be separate property. So what might that be? Well, anything that's backed out that might be separate property might be an inheritance. If you got an inheritance during the marriage, it doesn't necessarily mean it doesn't necessarily mean that if you got an inheritance during the marriage, that it's going to be community property. If you got inheritance and it was left to you and your spouse, it's community property. If you got inheritance and it was left to just you and you kept it in a separate bank account, then it's going to be your separate property. So that would then be backed out of the circle of community property. Same thing for gifts. If money was gifted to you and not gifted to you and your spouse, this is an issue that comes up. It's going to be your own separate property and backed out. If you have, let's say, gains or income on assets and property that you owned prior to the community starting, those are also going to be backed out and be separate property. So once you know what's in the community, and that can be easy to figure out. If you had nothing coming into the marriage and neither party did, it's always a lot easier. If it's a second marriage or a marriage a little bit later where you had assets first, it might be a little bit harder. But first we figure out, what is the community period? What's that time frame? What assets are part of it? What gets backed out that might be separate property? And then we figure out how to divide it. So the next thing I'll tell you about that is that Washington is not a 50-50 state. Some people hear community property. You've probably heard this before too, if you've been with us in the past, and they think that means we divide it down the middle. That means half and half. It does not mean that. In some states it does. But in Washington, we are what is called a just and equitable state. So that means how you divide the property is going to depend on the situation in your marriage, how long you were married, what the financial resources are of the parties at the time of divorce, what they have been during the marriage, what the income potential is of the parties. And then the court usually will allocate the resources, however. But most cases don't end up in court. You just kind of structure a settlement based on what might be just and equitable and what the basic guidelines are. So we're not a 50-50 state. It doesn't mean that sometimes assets and debts are not divided 50-50. Sometimes they definitely are, but it means that's not an automatic and definitely not a given, and does not happen in every case. So I think it's very important people know that, because a lot of people just think half is mine and half is hers, and that's not the case. So important that you know that as well. I'm going to give you another tip before we take a few questions. Don't hide money. So I told you that list of things to put it together. And if you have to exchange it in your divorce, which you will, or you have to provide it in discovery or informally or to the court, don't leave an account out and think, oh, no one's going to know I have that little savings account over there, or no one's going to know I have, this brokerage account. Or don't hide it, because just because you don't voluntarily provide it doesn't mean that the other party is not going to find it or have access to it. Your financials, when you're a party to a divorce case, can be subpoenaed. And you might think, well, no one's going to know I have an account at that bank. It's not uncommon that someone will open an account at a bank because they've never banked there before and they think no one will know about it. Well, in certain cases, you can use a forensic accountant to try to find money. Your attorney can send a subpoena basically to every banking institution in Washington, and they will get an answer if you have resources. I have caught people who said they didn't have accounts before very easily that way. The tax return is also a great source of information when people say they don't have accounts here or there or other assets. A lengthy tax return can tell you a lot about what's going on as well. So don't hide anything. Don't hold back those accounts. Be honest with your attorney about what you have, as well as in the process, because sometimes you might say, oh, I'll just give these to my attorney, and my attorney can only provide what they know that I have. Don't hold back at all. If there's something you're concerned about, or you think, I'm really worried I'm gonna have to share this money and I shouldn't for whatever reason, it's much better to tell your attorney that and figure that out ahead of time, because if you try to hide something and you get caught later, there can be penalties, especially if you hide something in a settlement. It's very common that any hidden assets that are discovered later will go 75% to the person they were hid from and 25% to the person that did the hiding. So that's an incentive not to do that. Can also be a reason to have a case completely vacated and undone. It can be a reason to get you sanctions during a case. It can be a reason to destroy your credibility. And I'm just saying this because people have the best intentions, and sometimes they really think, if I just leave this out, no one will have to know. Don't do it. It's just not worth it. So before I go on, Melissa, do we have questions? I think we probably do.
We have a number of questions, so in both our chat and Q&A, so I'll ask a few of them.
Sure.
So you were talking about necessary documents earlier. Somebody's asking if there is a list of these necessary documents that you could share. Or if you
I can't really share it during the webinar, but I can tell you again what they are, so you can write them down. That would be fine, and I think you should. So, but yeah, unfortunately, I don't have a way to share that right now, but it's pretty easy. When I talked through it, it might have seemed like more than it really was, but it's just basically, here's the bare minimums: 6 months of pay stubs. If you don't have pay stubs, 6 months of whatever your income source is, 2 years of tax returns, including all schedules, and 2 years of W-2s to go with it, and 1099s if you have a lot of 1099 income. I didn't mention that before. If you have that, those have to be included with the tax return as well. If you own a corporation and you have 5% or more of any kind of business interest, business tax returns. And then 6 months, this is the big one, 6 months minimum. You might want to go for a year on this one, of any statements for any financial institutions you have an interest in. Credit cards, bank accounts, mortgages, financial investment accounts, 401ks, 403bs, anything that you have an interest in. 6 months of statements on that. That's super important, and it can take a little while to get together and organize, but you can download those online from any financial institution for the most part, especially if they're recent statements. So just do it. You'll be really glad that you did. And then if you've received any gifts or anything that isn't showing up, in any of those statements, if you've received a gift or like a grant or something like that, or you receive income from an annuity, you'll need something that shows that as well. So that's the basics. So I don't have, sorry, I wish I thought to do a little slide on that, but since I didn't, at least hopefully you got a chance to take those down.
All right, awesome, thank you. Another participant is saying that they've been representing themselves during their divorce, have a temporary order for parenting plan and financial help, including spousal and child support. But now the soon-to-be ex has a lawyer and wants to stop financial support. What do I need to do to let the courts know I still need that support?
Well, if there's a temporary order in place, they can't just stop it. They could go to, this is just really generally, you probably need a lawyer, honestly, if they have a lawyer. There's no reason that one party should and the other person shouldn't. I can tell you this too, that good for you for working on representing yourself. It's a difficult thing to do. I'm a lawyer. When I got divorced, I certainly didn't do it myself because it's an emotional, difficult process. Other attorneys who don't practice family law don't do their own divorces. And sometimes it's like the only way for you, you think financially, but if one party can afford an attorney, you should be able to have one too. And divorce is absolutely the most complicated legal contract you ever entered into, probably without realizing it. So it's a good thing to get some guidance. But back to your question, if there is a temporary order in place allowing you to receive financial support, that order doesn't end just because someone wants it to. It would have to come back before the court on another motion for temporary orders to change the support for some reason, and there would need to be some kind of a substantial change in circumstances as to why it should change. It can't just be, oh, because I feel like it and my lawyer realizes I shouldn't have paid it or something stupid like that. There actually has to be a change in circumstances. Maybe if that person lost their job since when they started paying you, or you got a job and now you're making a lot more money and you don't need it as much, that could be a reason to revisit support. Otherwise, your financial support will be at issue either in settlement when you mediate, come to a settlement, or at trial. And then the court would hear both of your sides as to why you need support. And that will bring me to one of my next issues. They'll review your financial declarations. That's another thing you're going to need to know about that I'll tell you about, and determine what your need is, what the other party's ability to pay is, what your budget is, what you're spending money on. And in trial too, the maintenance award, which we're talking about support, we're talking about maintenance, also will be decided in tandem with how the property is going to be divided. Sometimes if someone is getting support, the court will say, instead of having one party make monthly payments to the other, I'm going to give one party just more of the assets. So, sometimes that's not always uncommon. So that's a little bit of information for you. I hope it's helpful.
Yeah, and the participant was also asking, it's sort of how you do these calculations on your own, and it sounds like it'd be pretty complicated to do as you're trying to take this back and forth without an attorney.
Yeah, well, bottom line is, if you can stipulate, which means agree with the other party on exchanging financials, and you can do that, but they don't have to give you financials. If there's a financial motion before the court, all those financials I told you are required from both sides, as well as a financial declaration, which we'll talk about after these questions. If you want to get those documents, all you need to do is serve financial discovery. I say all you need to do, like that's easy. It's not necessarily if you don't practice law, but you can serve a request for financials, and then the other party has to provide them within 30 days. If they don't, then there's a whole process that you need to go through before you can bring a motion to compel them. So getting financials can be easy or it can be difficult, depending on how transparent the other party wants to be, but ultimately they're going to need to be disclosed.
And then just sort of side note to wrap this line of questioning up, if there's a court date for a trial for this person and they would like to get a lawyer, maybe recognizing the need for one, can they request a continuance so that they have time?
Yeah. Courts actually, if you're going to trial, they don't know court wants to see unrepresented people there because it's really difficult for you and it's difficult for the court, because the court is supposed to hold you to the same standard as an attorney. I'd like to say they always do, but sometimes they don't, but technically you're held to the same standard as an attorney. And if you're not, it can be a basis for appeal to have a case overturned. But if you go to the court and you say, hey, I need a continuance because I need to get a lawyer, they've got a lawyer, the court's going to give you a continuance. It's if you have done that like 3 times and said, I'm going to get a lawyer, I need a continuance, and you still haven't done it, then the court's probably going to say, no, you had your chance. But if you haven't done that yet, do it, and the court will let you, do that. So you might need to you probably either need to bring a motion for trial continuance, or you could ask the other party's attorney if they will stipulate to agree and do an agreed motion for a trial continuance. They probably will, because most attorneys very much appreciate it when there's attorneys on both sides.
Awesome. Okay. Another question, when it comes to the calculations and support and all those things you're talking about earlier, do the courts typically do all these calculations, or is it an independent analyst, or is it a negotiation between mediators and lawyers? Who makes the final determination?
The courts don't want to do calculations. Let me tell you the life cycle of the case really quickly. That'll help. First thing, case gets filed. This is most cases, not every case. Second thing, sometimes there's temporary orders that go into place if you need them. If there's not, they don't. Third thing is you either exchange financials informally, or somebody does discovery and you guys get financials that way. Everybody gets a full picture of what the assets actually are. Then you move on to preparing your position and negotiating. So if you're doing a child support calculation, I'll tell you briefly about child support. It's based on the income of the parties, the age of the children, and the county that you live in. There's a statutory formula where you plug that in, you plug in the applicable tax deductions, you plug in the applicable amount you can do for retirement. One party might get credit for a portion of the medical premiums they pay for a child, and then there's a calculation. And it's not a math calculation that you can just do. You need a calculator to do it, a child support calculator that follows Washington's formula. So that's an easy one. Child support's like the easiest one. Maintenance, there's no calculation and there's no formula, but everybody makes their pitch for what they think their position should be. And it's based on the case law, and it's based on the statute that governs spousal support or spousal maintenance in Washington that evaluates a number of things. In a short-term marriage, maintenance post-divorce isn't very likely. In a mid-term marriage, maintenance is done usually somewhere on a 3 or 4 to 1 year formula. 3 or 4 years of marriage equals 1 year of maintenance. There can be a number of different factors that impact that. And in a long-term marriage, which is 25 years or more, you're looking at equalizing the parties, sometimes for life, depending on how old they are and if one party is still working or not. Short-term marriage is usually 5 or 6 years or less. Mid-term marriage is basically everything 6 years on up into the 20s. So there is a lot of discretion in maintenance cases. Court, you could go to 5 different courts, present your position 5 different ways, get 5 different answers, and they'd probably all be somehow right. So the court isn't going to figure it out for you most of the time. They might decide something different than what either of you propose, but both of you are going to propose your own situation. You're going to do your own calculations for child support. You're going to do your own proposal for maintenance based on the underlying financials, and the court's going to make a decision. The court likes well-supported, well-informed, well-documented positions, so it doesn't have to do the work itself. Sometimes it will, but sometimes you want to give the court something that's easy to say yes to, that's well-supported by the law and the facts. So if you can do that, you're in good shape. If you just go in and say, give me what's fair, the court's going to be like, why are we even here? But anyway, I digress. I said, okay, then we get to negotiation. So you're doing your calculations, you're figuring out your position. You might be going to the other party and saying, can we negotiate this without maintenance or trial? I'm sorry, without mediation or trial. If it's not very often worth it to spend a ton of time and resources negotiating if you're not getting anywhere, because every case in King, Pierce, and Snohomish counties right now is required to have a mediation before a trial. And a mediation in a typical family law sense is not everybody sitting around a table and chatting, because that very rarely gets results when people don't get along. It can be you and your attorney in one room. It can be a Zoom room like this. It's just how we're doing them right now. The other party and their attorney in the other room, and an attorney mediator shuttles back and forth. We call it a shuttle mediation, carrying different positions that have been put forward with financial support, supporting documents before the mediation. Most of the time, I'd say I've done hundreds of mediations over the years, and I really like them. And I would say 90% of the time it settles your case without the need to go to court. If you don't settle at mediation and you end up in court, then you prepare your case for court. Also worth noting, if you have a domestic violence situation, There's a domestic violence order, no contact order. Mediation is not technically required, although right now, since everything has changed and we're doing this all via Zoom, I have had the court require mediation since it's not face-to-face in most situations, and parties can have counsel, and it's done via Zoom. It doesn't violate protection orders. I've had courts order mediation anyway, but it is worth noting that. So it's basically file a case, maybe have temporary orders, exchange financials or whatever else you need, get the same page of discovery, and then move on to negotiation, and then mediation, and then maybe trial. And in a typical case in King County, that life cycle can take between 9 and 18 months, depending on how long it takes. But trial is usually at least a year. So anyway, I hope that that's helpful.
Thanks,
Is there
Michelle.
anything else, or should I move on?
There's a few more questions. I have 2 questions that you were talking earlier about advising people definitely not to hide money. And there's a couple of questions here. One says, what if the other person is hiding money under their parents' account?
Well, if they're hiding money under your parents' account, that's going to be difficult. But if you can show that they transferred money from their accounts to their parents' accounts, then it becomes easier. So that's another reason why you're going to do, like, very often in a case, we'll do financial discovery and get financials, the last few years, and we can see if there's been big transfers or wires or whatever to someone else. So if you're hiding money in your parents' account, it had to get there in some way. So you basically will kind of follow that trail. And then, you could do things like, if it ever came down to it, depose the parent and ask the parent under oath, what's that money for? When did they give it to you? And you will find that people are, even if they want to protect their children, they're usually not going to lie for their kids under oath.
And then on a similar tangent, somebody's asking how to stop the other party from hiding money in other states or overseas.
Well, same kind of a situation. I mean, if somebody is moving money to like an out-of-state bank account, we can still get that information. You still have to provide it. I should say that. When I'm talking about all statements, 6 months of them, that includes if you have money overseas. That includes if you have money in a bank account in Oklahoma. You still have to provide it, and we can still subpoena out-of-state banks. So if someone's doing that, the other thing to note too, this is very important and fundamental, is once a divorce case is filed, there is what's called an automatic temporary restraining order that goes into place at least in King and Snohomish. In Pierce, you have to ask for it through a different process, but it says no one can buy, sell, or encumber property or make large transfers out of the course of everyday usage unless it's for attorney fees, because that's everyday usage during a divorce. But you can't say, oh, I'm going to move $50,000 to this account in the Caymans or whatever. You can't do that. And if you do, you violated the automatic temporary financial restraining order, and the other party can hold you in contempt and you can pay fees and the court's not going to like you. So file your case, and that stops people and kind of puts a hold on things. It doesn't technically, nobody reaches out from the court and puts a hold on your accounts, but it puts an order in place that prohibits people from doing that. And if they do, there's ramifications. So file a case if you're really worried about people moving money. That's the best thing I can tell you. So,
a couple more questions. I don't know if you want
sure.
to.
You know what? I think it's fine. Let's go 5 more minutes on questions, and then I'll go back to some content. I'd rather answer questions that are related to this, so I'm fine to do. Let's just do 5 more minutes. That's fine.
Okay. You were talking about discovery earlier, and there was a question just about how much it costs for discovery. I know that's not an easy answer.
No, I laugh because I think it's funny. I laugh because that's a great question. Discovery can cost a little, or discovery could cost a couple $100 to send out answers. You get those answers back quickly. A couple $100 more for another hour of time. Or I've seen discovery cost $30 or $40,000. So I mean, it depends on how. Is someone gonna discovery means a lot of things too. It means sending out interrogatories, getting them back. You can send multiple sets of interrogatories. Discovery can mean taking a deposition of another party under oath. It can mean sending subpoenas. It can mean bringing a motion to compel discovery. So discovery could be a little or it could be a lot. Best thing to do is discuss with an attorney what your situation is and what your needs are. Also too, I mean, I'll send out discovery sometimes, and maybe I've only sent 3 pages of very limited specific questions, because that's all I need to know. I don't need a bunch of other stuff. Some attorneys, sometimes I'll be like, oh, I need to know a lot and I want to make it really hard for their party. So I'll send 100 pages of stuff they have to do. So it depends on your case. And someone could do that to you. That's the thing. If you serve discovery, you better be prepared to have it served back. So yeah, it depends. And I don't say that because I don't want to give you an answer. I say that because it's not fair to you if I say, oh, it's going to cost you $1,000 or $5,000. And it costs you more or it costs you less. I mean, I don't know, because I don't know what your needs are. But discussing with someone what your needs are, and also too, when you have an attorney on both sides and they can have a conversation and say, we don't want to drive up costs here. We just want to get these people through this process. And if people are similarly aligned and situated, and there's, you know, it always makes more sense to spend less on discovery if you can, but at the same time, you don't want to leave money on the table. And so if you need to send out subpoenas because you know they're not giving you everything, it's well worth doing. So sometimes spending a little more on discovery is worth it to get the information you need. Sometimes I've had cases where I don't need to do discovery at all. So anyway, yeah.
Can you comment on a situation where maybe the opposing party might have quit a high-paying job right before separation, has lots of assets acquired during the relationship, but now voluntarily making little money?
Yeah, I mean, I can comment on it to tell you that stinks. And it probably, the optics of that probably aren't that great for the court. Kind of depends on who you're in front of. I had a case not that long ago where something happened where a case was filed. Someone quit their, you know, six-figure job and decided they were going to go back to school. Court didn't like that and still told them you need to go back to school and get a job and pay maintenance anyway, but you already have a master's degree, you don't need a doctorate, kind of a thing. If someone quits their job right before separation, you're going to need to paint the picture of what the historical income has been during the marriage. Also kind of depends on how long the marriage is. If the marriage is like a one-year marriage, the court's going to be like, well, you know, you're not going to get support anyway, so kind of who cares? If it's like a 20-year marriage and this person was the breadwinner and now they've quit their job, that's not going to look good, and you're probably going to want to seek support at some point. But it's also difficult if they are trying to paint the picture that they lost their job, they're trying to find a job and they can't, or whatever. But that's a very fact-specific situation. This comes up, unfortunately, in a lot of cases. But I'll tell you this too: if you're thinking about quitting your job, anybody that's out there, don't, because the optics of it are bad, and it can really, really backfire on you. And if you, let's say, are making $150,000, and you think, you know, I don't want to do that anymore, I don't want to pay maintenance, and the other party's only making, you know, $30,000, like in a part-time job, I'm going to quit my job and I'm going to go get a job. You know, working at Home Depot, and it's still a good job, but I'm only making 55,000, like 100 less than I used to. The court's going to be like, no, you need to get a job that you need to be employed. You're voluntarily underemployed. And that's the thing too, is being a stay-at-home parent is one of the hardest jobs. I'm not saying it's not, but the court will think that you're voluntarily or underemployed, and they won't, maybe if you've been staying home a long time, necessarily expect you to work right away, but you will need to go back to work, or you'll need to be imputed for income up to a certain amount. So I'll take one more, Melissa. Is there one more that you want to give me?
Yeah. If mediation does not work, can it be solved through arbitration? Does this require consent from all parties?
Yes, you can't arbitrate. You're only required to do dispute resolution, which could be mediation or arbitration. It could also be both. I've had some cases where we will stipulate to mediate, and if we don't settle in mediation, maybe we'll do a second mediation, or maybe we will stipulate to resolve the issue through binding arbitration. But the parties have to stipulate to arbitrate, and not often do both parties want to arbitrate. One party might really want their day in court. The other party might want to do arbitration. Quick note on arbitration. Arbitration is kind of like a private trial with an arbitrator, not a judge. The rules are a little bit different. The rules of evidence are still the same, but you don't necessarily have to do things procedurally the exact same way. It can also happen a lot faster because there's a huge backlog on trials right now with COVID going on, and criminal trials come before civil trials, and family law trials, and cases with kids come before cases without. So you could end up being pushed down the road a lot. So sometimes courts really like it right now if you're willing to arbitrate, but you also have to pay for an arbitrator's time. Although arbitration can be more efficient than trial in different circumstances. But yeah, both parties have to stipulate to arbitrate. But a lot of times doing what I would call like mediation arbitration is a great way to do it. If you just want to get your case done sooner and you're both comfortable with that. So good question. So what I will do is I'll give you another tip, and then I'm going to just talk about a few more issues. You guys have some really good questions, so I could probably do a part 2 on this webinar as well. Let's talk about, first, another tip is this: if you're separating, set up your own bank account. And maybe you have a situation in your marriage where you already have one. Great, then you don't need to listen to this. And I'm not saying anything bad about the people out there who don't have their own bank accounts during a marriage. That's completely fine. Everybody handles finances during a marriage differently. But I mean, for the love of God, set up your own bank account when you're getting separated, and do not rely on having an account where the other party is going to see every single thing you're spending, because that will just lead to problems later. If you have a joint bank account during a marriage and you guys are super amicable and you're not worried about high conflict type things happening, and you don't think that your spouse is going to yell if you decide to take the kids out to Red Robin instead of cooking something at home one night and saying that you're wasteful, whatever. Or if you're going to go somewhere for the weekend with your sister and you don't want the other party saying that you went away with some illicit lover, then fine, share the same bank account and let them see what you're doing. But for the most part, I gotta tell you, it makes so much sense, and it's cleaner from a financial perspective. Set up your own account and then have your check go into your account post separation. This goes back to what I was talking about before. When you are separated, the community ended. So if you're both spending out of the joint account, we're going to have to figure out who spent what post separation out of community money and who spent what out of separate money. If you are going to, and I'm not saying cut off the other party completely if you're the party, the breadwinner, and the one paying support, but put your check in your account and then transfer money into the joint account for, support or joint savings. I'm sorry, not joint savings, joint expenses or whatever like that you're helping support post separation. But set up your own account. That way you can deal with your own post separation spending. You can deal, and it doesn't mean the other party's not going to see it, because they might see it if there's a motion, but it just means that it won't be every other day them looking at the account and being like, what's this, you don't want that. And at the same time too, you want to then put aside money for separate expenses or joint expenses if there are still community things that you guys are paying on, debts that there's an agreement on, whatever. But set up your own accounts. It's just much easier and cleaner. It'll make it easier for you to be able to say, this is my account. It's all post-separation. I get to keep it at the end of the divorce, and everything in there is post-separation income or whatever. So do that. Set up a checking account and a savings account. Doesn't have to, it can be a free one. Who cares? Just set it up. Another big tip is don't cut the other party off financially. If you're mad and you're like, oh, he cheated on me or he did this or that, I'm cutting him off the account. Don't do that. It looks terrible. It looks bad. If you have a status quo of the fact that you are paying for things, continue paying for them until there's an order otherwise and negotiate a temporary order. Don't just cut someone off. You can't do that anyway if a case is filed under the automatic temporary financial restraints and it looks bad. It looks like what the court calls engaging in self-help, which means I engaged in self-help. I decided you don't need that cell phone anymore. Don't do that. It just looks terrible. So those are a couple of things of what not to do. I'm going to talk about a couple common issues, financial issues, before we see if there's any more questions and close out. And like I said, I think we'll do a second webinar on this because this is a really good, important topic. Home, the house, the family home, value of the family home. Who's going to stay in the family home? This is like a huge thing. Sometimes you can't, a big mistake that we see from different attorneys that don't know what they're doing is they'll divide the value of a family home on a spreadsheet. You can't do that. You can't cut a house in half. You could do that if the house is being sold and you're doing that, what I would call a demonstrative way of saying, this house is probably going to sell for $1 million and they're probably going to split it. So we'll just do that for whatever. That's fine. But if someone is like keeping the house and you're dividing the house, you can't split it up on a spreadsheet. It doesn't work that way. What you can do is you might be saying one party is going to keep the house and buy the other party out. There's a different way to show that. And if that's the case, what do you need to know? You need to know what the house is worth. And what's going to happen? Someone's going to go on Redfin, I promise you, and they're going to say it's worth this much. Someone's going to go on Zillow and be like, oh, no, it's worth 100,000 more. It's worth this much. And then both of those people are going to be wrong because the only thing that really controls is if you go and get an appraisal. So if one party gets an appraisal and says it's worth 800,000 and the other party gets an appraisal and says it's worth 850,000. All right, now we're talking about competing appraisals. Sometimes the court will split the difference. Sometimes the court will, if you're really in court about it, or a mediator will encourage you to split the difference. Sometimes someone will say, gosh, your appraisal is a lot more recent and that's probably the one that's going to control. We'll go with it. But spend the money and the time to have your attorney get an appraisal done. No one cares what Zillow or Redfin says, and you can't use those in court. If you end up in court, you have to have an appraisal. You also probably want to do a couple CMAs, which are comparative market analysis. Realtors will do those for free. And I have actually seen those control in court a couple of times, although most judges are more comfortable with an appraisal. But a CMA is important because it informs the client, it informs your attorney, it can inform the court or a mediator what the market conditions are and how far off an appraisal may or may not be. And you can get a couple of those and those are free. So you need a value for the home. Once we figured out what the value is, then we can figure out if it makes sense for one party to keep it or not, and you can buy the other party out. Really, really, really important to know about that as well. I'm going to throw this out there is refinancing or purchasing a new property. do not assume that you're going to be able to refinance a home to get the other party off. And that's a very big thing. If you want to keep the home, you might end up realizing it's better for you to sell, or you might be able to refinance and keep it. But you'll need to speak with a lender before your divorce happens, because once a divorce is filed, you can't do anything until it's finalized. And a lender will tell you too that if you want to include spousal maintenance as income, if you haven't been working, you're going to need to have it for at least 3 years. There's a lot of other things you need to know if you'll really qualify or not. So speak to a lender, and we always have our clients do this. Speak to a lender before you come up with a plan on the house. You need a value on the house, and then you need a plan, and then you need to find out, can I keep it? Because if we're both on the loan or the other party's on the loan, you can't keep it unless you can get it in your name within a reasonable amount of time. So a lot of things to know there. But the house, the reason I'm bringing it up is because the house is the biggest asset for most people. Some people it's not. Some people have more in stock, or they've got more in, their IRA or whatever over the years. But for most people, the home and real property is kind of the big thing. So there's a lot to know there. And like I said, we could talk about that more another time. Another big issue is mixed accounts. What do I mean by that? Well, let's say wife's working at Boeing, and she started working there 30 years ago, and she's getting really close to retirement. She's like long-term Boeing person, right? And so she worked there for 10 years before she met husband. Then she meets husband, and when she meets husband, she keeps contributing to her Boeing VIP account and her 401k, and everything's going along great. And then those 20 years she's married to husband, and the kids have moved out, and they realize they don't like each other anymore. And she wants to travel, and he wants to move to another state, and they're going to get divorced. She's got these two accounts, and they got a lot of assets in them. And a lot of those assets are community, but 10 years are not. That's a mixed account. It's got a separate property value in the time before the marriage, and it's got a community value during the marriage. This happens all the time. And it doesn't have to be a 30-year window. It could be a 6-year window. I mean, you could have 2 years of separate, 4 years of community, or whatever. And what do you do in that situation? Well, it's not as simple as saying, here's what the account was when we got married. You get everything, you get that amount. Here's what the account is now. No, it's definitely not that simple, because there are gains and losses on the separate property amount and a community amount. So what you really need to do is have a valuation done, showing what the separate and property portions are and what the gains and losses are on each time period and each amount of money. And there are professionals that do that we have do that. So there are answers to these questions, is what I'm telling you. Sometimes it takes actual professional support to get those answers, but there are answers to these questions. And I tell you that too. So if someone tells you, oh, I'm not just giving you what that value is, they're not trying to be like a jerk about it. There actually is, because there are gains and losses on money, and there are valuations that have to be done with mixed accounts. Another really quick, I know we're running short on time, but another really important issue as far as financials goes are restricted stock units. So RSUs are a huge thing. I'll just use Amazon for an example, Microsoft too, other smaller tech companies, but they're a huge part of the compensation structure at somewhere like Amazon. That person might get a lower base salary, but gets a grant of what are called RSUs every year, and then they vest over a certain amount of time. So you need to know which which RSUs were granted during the community, what's vested, what's not vested, what unvested portion does the community have an interest in, and there's a lot of different things there. So RSUs and also options are a huge financial issue that needs to get resolved. Mixed accounts are a huge thing. It's easy if someone just had a 401k and they never rolled it over and it never became community. Any money you've made if there were no community contributions is easy. That stays separate. So I'm not talking about those accounts. I'm talking about mixed accounts. Pensions and figuring out, unfortunately, a lot of people don't have pensions anymore, but if someone worked for the Postal Service for a long time and, 5 years are community and 20 years are not, well, there's a 5-year interest in what that pension is. And so we need to have that calculated. Military pensions, all kinds of things like that. So I could go on and on and on and on and on. Bottom line is there's a lot of issues. Don't hide money. Be realistic about your budget. We didn't really get to this, and I'm kind of bummed about that. So we'll have a whole other webinar, I promise, soon about budgeting and financial declarations. You need a financial declaration. Every single time you submit all those financials to the other party or to the court, financial declaration is basically a budget. It goes through what your income is and what you're spending on everything. And it's gonna be very important that you talk with your attorney about whether that $1,800 a month that you're claiming you spend on food is gonna be seen as reasonable, because it's probably not, unless you're feeding a ton of people. But for 2 people, $1,800 is gonna be seen as no. Or whether, you know, someone's claiming that they really need Botox or whatever. I mean, don't laugh, because this is something that happens, and the court might be like, why do you you need that? Like, is that a medical necessity right now? Probably not. Or you know, are you spending money on something that you don't need to be, like $600 a month on clubs because you go to a private club or something? Court's not going to see that as reasonable during a divorce unless it's something you've been doing for a really long time. But anyway, financial declaration 2 will go over what your utilities are, what your housing payment is, what it might be, and what it's anticipated to be. So a financial declaration is a huge thing. I'm sorry we didn't get a chance to get to that, but we will. We'll do another one of these. So don't hide money. Be realistic about your budget. Consult with your legal team about putting together a realistic budget, because you look really, really bad if you were claiming these crazy expenses that don't exist. Or if the other party is, then we kind of pick on it. Like, I've so many times been like, this financial declaration is inflated. This person is eating out like more than, I mean, you know, I don't know who, a manager to make, it's insane. So you got to be really realistic about it. Gather your financials, organize them, do your 6 months of statements on everything, do your 6 months of pay stubs, get your tax returns together. If you don't have access to those things because you're not the person that controls the finances, don't stress or worry about it. Just let your attorney know, I don't have these things. The other party has control of it all. Cool, we'll get it for you. Like, you know, don't worry about it. Knowing what you don't know and what you don't have is just as important. So that's another thing to know. And don't panic. That's the biggest thing. Talking about money, like, it makes people's blood pressure go up. I mean, I'm not even talking about my money, and I can feel it like happening. So your blood pressure goes up. You start to think about, I can't afford this. Resources from one house now have to be for 2. How can I keep the house? I don't want my kids to have to move out of the house. All this is very normal. If this is going through your mind, don't panic. Relax. It's going to be okay. You will get through it. People in way worse situations than you get through this. Get a support team. Talk to someone like Melissa. Talk to a therapist. She can help you deal with the stress much better than I can. I can help you deal with the financial issues, but it's not a good usage of this is another financial issue. It's not a good usage of your money to talk to an attorney about how stressed you are all the time. I want to know and I want to help, and I'll try to, like, you know, help you deal with it by giving you answers. But if you are just having a lot of anxiety, spend the resources and time to talk to someone who's trained to deal with that. Highly recommend it. If you are in a situation where you're not sure if you want to go down this road, do some divorce ambivalence counseling, talk to somebody first. But also, I highly recommend do a consultation with an attorney and hear about what your options are. Am I likely to get spousal maintenance? How much do you think I'm going to get for child support? Do you think I can keep the house? Is that even realistic under this scenario? All those things are things that someone needs to do a very fact-specific look at your case. And that's not also too, all your questions aren't going to be answered in an hour. That's not realistic, but you just get information. Information is power. Information will help you, especially when it comes to finances. Melissa, I will take a few more questions before we go.
Okay. You were talking about getting the appraisal for the home. Is the appraisal based on time of separation or court date?
It's based on when you're getting it, and it's based on when you're settling. This is the thing too. People hate this, but let's say I separated in June of 2021 and my case is grinding on and it's like taking forever, right? Well, it's now, let's say it's May of 2022 and we're getting ready for trial. You got to have the current value as of then. Nobody cares about what the house was worth when you separated. It's a current asset. So you have to have, might be helpful for you to say, oh, this is what it was worth, and these are the payments that I made post separation out of my separate property. I want credit for that. You see some people doing that, but the principal pay down over a year actually really isn't that much. You need to have an appraisal current at the time you are settling a case, not at date of separation. That's confusing. So that's a great question.
Yeah. Okay. What if you need to buy furniture to set up an apartment and your spouse?
Great question.
Spouse is living in the nice house with all the furniture. Can you buy furniture under the joint account? Sounds like in this particular situation, this person is not employed.
Yes, absolutely.
They won't leave the house because they didn't choose the divorce.
Well, that's silly. You need an attorney. Whoever should stay in the house should be the person that probably doesn't have a job. And the person that does have a job maybe should move out and get an apartment. But if you want to move out and you're like, I can't do this anymore, I want to move out. Yeah, you can, I mean, don't go buy I don't know, like, don't go to Crate and Barrel and buy their most expensive. They have great stuff, by the way, but don't go to Crate and Barrel and spend $8,000 on a sofa. Go to, you know, something decent. I mean, who knows? Buy the $800 sofa. Don't buy the $8,000 sofa. Is what I'm saying. But yes, you can spend reasonable money, because that, even if your case has been filed, I don't know if it has been in your case, but even if it has, the automatic temporary financial restraints allow you to spend money for life's necessities. Having pots and pans and a bed to sleep on in your apartment is a necessity. And yes, you should be able to use community funds for that. If you're in a situation where you don't know how much you're going to have per month and all these things are going on, and it sounds like you might need some temporary orders. And if there are assets, like if there's a joint savings account, I just talked to someone about this the other day. She was like, I really want my husband to move out. And, we have this 5,000 sitting in this extra savings. Can I just give him that and tell him, go get a place? I want you out. And I said, yeah, I mean, if he agrees to it, great. And then you can say, because we're separated and he's moving out, that $5,000 could be seen as a pre-distribution of community money in settlement later. So, you know, if you spend money, maybe it's post-separation, so it's part of getting, you know, your resources set up, and that factors into settlement. But absolutely, you can spend money on life's necessities to set yourself up in an apartment. And you know, don't hesitate to talk to an attorney about if you're worried about the spending and is this going to look bad or whatever. I mean, it also too depends on the standard of living during a marriage. It doesn't make sense for one party to be living in the big house with all of the nice stuff and, you know, 4 TVs, and the other party to be living in a studio without it. So, you know, keep that in mind.
Mm-hmm. So I know we are kind of here at the end of our time. I want to just thank everybody for coming. I know, Michelle, if you have anything you want to say to wrap up, but I'm put our contact slide here on the screen so that people can know where to call or email if they want to.
Sure. Yeah, no, I appreciate everybody coming. Thanks a lot. And I'm sorry we didn't get to all the topics, but I actually think answering your questions is more valuable and beneficial. So we got through some good ones. We will do a second webinar on financial deep dive because there's a lot of things we didn't get to. I want to talk more about spousal maintenance, child support. We talked about debts and assets a bit, so that was good. But generally, thanks for coming. If you have questions, don't hesitate to follow up, schedule a consultation. If you're not ready to schedule a consultation, no pressure there at all. But keep this in mind too. Don't get your legal advice off Google. Google is not a substitution for that. I'm really guilty of, I don't feel well and I'm going on to WebMD and then I'm telling my husband everything that's wrong with me. And he's like, where'd you get your medical degree? Because I don't have one. So that's not, I liken that to when people are like, oh, well, I saw this online, or, oh, my friend's divorce, this or that happened. Don't think that what happened in your friend's divorce applies in yours. Don't think that what you read online is necessarily, you know, what's out there. It's super important to get information. So if you're talking to people and looking online, I don't want to discourage that. It's probably how you ended up here, but go to people that know and get information tailored to your situation. Because I will tell you this as a final tip, I guess. Divorce and separation is extremely fact specific. There are basic things that, you know, are law in Washington, but how you have to figure out how your specific situation applies, how the rules of law are applied to your situation, because people's lives are different, people's families are different, people's expenses are different, and it's not going to be the same rule and application and outcome for everyone. So your friends might mean, you know, have the best intentions, but don't think that what they're telling you is necessarily going to be true in your case. Google might have a ton of information, but don't assume that what you read is absolutely what's going to happen. You know, if you do that, you go down a rabbit hole of fear. You can be really scared. You can get information that is not reliable for you. Don't do that. Talk to someone that knows. And that really should be an attorney when you're talking about divorce. You know, also to get support, talk to a therapist, talk to your friends, definitely do that. But this is the last parting, I lied, that's just the last tip. The last thing is talk to your friends and family, but I say this in every webinar too, don't post all over social media about your divorce. Don't talk and say horrible things about your spouse to everyone you know. Pick a close group of people if you're going to vent. Totally okay to vent, totally healthy. Find a therapist to help you process some of those emotions, but don't post everything out there, because anything that you post online, any nasty text messages that you send to someone, just assume that those are eventually going to end up in a court file, or they're eventually going to end up in discovery, or you know, they're just going to generally be used against you, even if you're the one that was wrong, to make you look bad. So don't do those things. Find a close circle, talk to those people, basically form a team, you know, somebody to help you on the financial side, someone to help you on the legal side, someone emotionally, and the close trusted friends and family members that you know are going to be there for you. Tell them what's going on and get their support, but don't blast it out there. You can do that when the divorce is over if you want, but don't do it beforehand. Because financially, since we're talking about financials, this really does tie back to that. You will spend legal fees and time and money to deal with that kind of thing, and that's so not helpful to you. So save yourself time and money. Keep your venting private and keep your information close to the chest too, because you will want to use that strategically during your divorce. Thank you for coming. I wish you all the best, and I hope everyone is staying safe out there. Take care. Bye-bye.
Thanks, everybody. Stay tuned for our next webinars. We'll keep you all posted about when those are going to be. We appreciate it. Thank you.